But first, I want to make sure that we're clear, because you keep indicating that the Supreme Court has ruled on juvenile lifers without parole, when in fact, I believe their ruling was that they were not going to address that issue at that time. Is that correct?
You're talking about the United States Supreme Court?
I'm talking about Michigan.
Well, the Michigan Supreme Court is, it's been pending, the Michigan Court of Appeals ruled in People versus Karp that Miller is not to be applied retroactively. And that case is pending review by the Michigan Supreme Court.
Okay, but didn't the U.S. District Court for the Eastern District of Michigan rule that it would be retroactive?
That's, I think you're referring to Judge O'Meara's decision?
Yes.
Judge O'Meara made that decision. I disagree with it, and frankly, it was no disrespect, but pretty thin on the legal analysis. And what'll happen? But that's all right. And what'll happen is there'll be an appeal that'll go through from the United States District Court to the Sixth Circuit Court of Appeals. Maybe there's an en banc review, and then it may go to the and eventually this issue, whether it's the decision from the Eastern District of Michigan or some other district across the United States of America, will be ruled upon by the United States Supreme Court 2 or 3 years from now.
Well, we know some other district across the state of the United States wouldn't be binding on Michigan, but the ruling from the Eastern District is in fact binding.
No, it's not binding.
Okay. And you said you don't agree with it, so is it your position that until you're not going to comply with it until it's something that you agree with, or we need to wait until the Supreme Court of the United States rules?
Yes, the Supreme Court of the United States is the final arbiter, the law of the land. And when and if the United States Supreme Court makes that decision on retroactivity, then it would apply.
But you would agree that it's persuasive,
What would be, what's persuasive?
the ruling from the Eastern District?
No, I would not agree. And respectfully, I would not agree it's persuasive.
Okay. You also indicated that, and ultimately, I guess, let me first say and be clear that there's a lot of individuals in this room wearing red roses, and I'm going to suspect that those are individuals who have been family members who have been victims of crimes. And I too could have a red rose if one was offered to me. I was born and raised in the city of Saginaw, and I see crime firsthand. I'm a former correction officer, having worked in the prison, and a former assistant attorney general, having prosecuted and defended cases throughout the state of Michigan. So I know the criminal justice system firsthand. I also know the notion that we can just say we need to get tough on crime. It's not something that has been sustainable or that can continue to be sustainable. The corrections budget has increased 10 times over the past 10 years. But this is not a matter of just cost. This is a matter of, are we locking up those who we are indeed afraid of, those who are indeed evil, and who need to be locked up? So when you say that we need to have tough penalties, have you found that having tough penalties have decreased recidivism in any way?
I didn't talk about tough penalties this morning. I'm happy to talk about tough penalties, but today I was really talking about the voices of victims and how we need to make sure that in this discussion of teenage murders, we don't ignore or dismiss in a casual fashion the voices of victims. Now, with respect to, if you want to talk about tough laws, I happen to think that with the crime rate in the state of Michigan, we have four communities among the have the highest violent crime rate in the United States of America. 2 have the highest murder rate in the United States of America. We need to make sure we have a complete commitment to public safety. And that's why I appreciate that the Michigan House of Representatives, the Senate, and the governor signed VO4 that imposed a 25-year mandatory prison term for fourth felons, fourth convicted offenders. Because I went to a funeral in Livonia, not far from Representative Heisey, when Officer Larry Niehazel was brutally murdered by someone who had 9 felonies and 4 misdemeanors and was out on the street. So I think there's something to be said about putting bad guys behind bars. Now, in terms of costs, let me just say this. In terms of costs, what we ought to do in Michigan is operate our prisons more efficiently, more cost-effective basis, where you bid out, you contract out, transportation, food, maintenance, cleaning, what have you, to bring our costs down and keep the bad guys locked up. Other states do that. We need to do that more effectively. That's my point. And I tell you, if you really wanted to reduce costs, you'd have no prisons. But that's not the point. The point is we ought to make sure that to be in prison in Michigan, you have to do something bad repeatedly. And we ought to make sure we differentiate between someone who's ripped off a CD at Barnes & Noble versus someone who's committed murder 1 or violent crimes.
And I guess, let me be clear again, I don't think there's anyone in this room, on this committee, whose heart doesn't go out to the victims. So with all due respect, to continue to go back to the big victims as if we're here to erode, the legislative process to get at victims, that's sad. And there's no way that I believe any legislator would do anything to harm a victim or make the victim the problem. The victim is not the problem. Am I clear on that?
Oh, I couldn't agree more. The victim's
so
not the
I believe
problem. We need to make sure that we don't forget the victim. That's all
No, and
I'm
the
doing.
victim, I don't think they will ever be forgotten, because if you're not saying victim, I'll continue to say victim.
Good.
We're about the victims. We're
Good.
on the same side on that. Just as another point and of distinction, I'm trying to figure out, how do you personally, Mr. AG, juxtapose your position of second chances? You say you believe in second chances. How do you differentiate your support of expungement, but only for individuals who are 21 years or younger? But in this case, when it comes to juvenile justice, individuals 18 years or younger, you can't find a way to see that those situations could be different.
Here's what I said. I said I'm a man of faith, and I believe in forgiveness. But I also firmly understand that there are consequences to bad or evil decisions. That's what I said. And I said that for the victims here, there are no second chances, only lost chances. And
I was talking about those 2 specific pieces of legislation, one that you were in support of, where individuals 21 and under could receive an expungement, but an individual over 21.
I don't think we're talking about murder 1 at all in those bills.
I think what we're talking about is an age.
No, we're talking about different crimes.
And not using it in an arbitrary manner. Right now, we're talking about juveniles who are clearly younger than 21, but in instances where an individual was 21 or younger, you could support those individuals receiving a second chance, but not someone who's 22 or 23. I'm just trying to get a clear understanding from you, Mr. Attorney General, where's your reasoning when it comes to that type of legislation?
I'll try to be as, again...
And I know you're a man of faith. I'm a woman of faith.
Good.
I believe that we should do right by victims. I believe we should protect society. I believe in public safety. I'm certified in law enforcement, all of those things. But at the end of the day, I think it's very hypocritical to try to juxtapose who can have a second chance and who can't, and arbitrarily determine where the age, and have a total disregard for court rulings. Again, we're not here to put victims in a position where they have to feel like legislators are literally trying to abuse our legislative authority in basically seeing where courts have ruled. We know in the direction they're headed, but to say that we're just going to wait another 4 or 5 years and see what the Supreme Court does.
Well, first, I'm a former member of the legislature, and not once today have I said any disparaging comment about you Representative Oakes, or anybody. All I've done today is done my job and responsibility of making sure that victims of crime are not forgotten. Secondly, we have a fundamental disagreement, and that's okay. And the fact is that you're talking about expungement. Did not involve murder one, did not involve the brutal killing of a person. So these are different as apples and oranges. And so I'm just letting you know that. We have a difference of opinion. That's okay. But to have civil discourse on these issues is important. Have a discussion on this is significant. And that's why I've been so pleased to be here today.
Thank you very much. Representative Kurtz.
Thank you, Mr. Chairman. Mr. Attorney General, I thank you. I'm going to never let you think that while I'm sitting here in this course of discussion that you've taken me into the weeds, and I'm going to, by my own expression. But I want to come back to something that
I'm glad to be.
that will
I
help
am
me.
glad to be here, so thank you.
Thank you. We talk about the juvenile, we talk about the minor, yet there's something that's been said a couple of times for my clarification, because my background is not the same as yours and many that sit here in the judicial system. We talk about these youthful people that have been convicted, and I understand that, but there's a question that I'd just like a clarification, won't take near as long. When in the court process do we regard that youthful person to be tried as an adult, where we took him from being a minor, him or her, to being a minor, and made his punishment or her punishment fit that of what we would commonly think of an adult? Does that, I hope I haven't gotten you into the weeds at all.
The prosecutor-
But we take and we turn around and we say they're youthful, but when they get into court because of a crime that was committed, they're no longer a youth, they're an adult. Is that what we're saying?
The prosecutor can make that decision in certain cases whether or not to charge someone who is a teenager who's may have committed a murder as an adult. The prosecutor has that discretion. Jessica Cooper will talk about that, I'm certain, the Oakland County prosecutor.
Okay, I'm just, because we switched from being a minor to now an adult, and the punishment and this sort of thing seems different. I, for one, would, I'm going to be listening for that.
I'm sure Jessica will talk about that.
Thank you.
You bet.
Thank you. Representative Robinson.
Thank you, Mr. Chairman. Good morning, sir.
Good morning, Representative Robinson. Nice to see you again.
Thank you, sir.
You're welcome.
I'd like a clarification.
I'll-
I always
I'll-
need help.
I'll try to provide it best I can.
All right. The Supreme Court, when it decided Miller versus, I just had it. When they decided Miller versus Alabama, they came out with a holding. And maybe I'm being too simplistic, but maybe you can tell me if this is correct or not. The holding was that life without parole as a sentence is unconstitutional because, under the Eighth Amendment, because it is cruel and unusual. It's not right.
No.
This young man's shaking his
No.
head. All right. Well, what is the holding in Miller?
The holding in move over a bit. The holding in Miller v. Alabama goes this way, that juvenile teenage murderers may indeed be sentenced to life without parole. Prospectively, the date the Miller v. Alabama decision was made, those teenagers must have a hearing. And the Miller v. Alabama did not rule on a retroactive application of that case.
Right. That's what I think everyone has to get clear on, what
Yes,
Miller
yes.
really says.
Exactly.
Okay.
And that's what the holding in Miller is.
It's
And the
prospective.
question is, what's the retroactive application? And there's a court decision called in Teague, spelled T-E-A-G-U-E, that says that procedural cases go